My name is Mark Abrish-Conlon. The impetus for this meeting began last December when the United States Supreme Court agreed to hear two cases involving the rights of same-sex couples for marriage equality. One is the constitutional challenge to Proposition 8, which was approved by about 52% of California voters in November 2008 and took away our marriage rights after we had been given them by the California Supreme Court. The other involves the so-called Defense of Marriage Act, which was passed by U.S. Congress with Republican majorities in both houses in 1996, signed into law by Democratic President Bill Clinton, who has since disavowed it. Not that that helps much. And colloquially known as DOMA, the Defense of Marriage Act has two clauses. One allows any state not to recognize marriages between same-sex couples legally entered into in other states. Unfortunately, the Supreme Court is not reviewing that section. The one they are reviewing is the one that says that for purposes of federal benefits and federal policy generally, marriage is defined as the union of one man and one woman, and therefore same-sex couples, even if they are legally married in the state where they live, do not get federal benefits. What we'll be discussing tonight are basically two topics: the options that the United States Supreme Court has open to them for deciding these cases, and what the queer community should do about the court decision, whatever it is. So to that end, I have assembled a panel of people who are attorneys, people who are activists, and people who are, at least one person who's an activist with a law degree, as well as the two attorneys who are kind of activists themselves. Our first speaker is Eric Isaacson, who is actually involved in this litigation, has filed a number of Friends of the Court briefs at various stages of the marriage litigation in California. He'll lead off. Next, we'll hear from Todd Moore, who was the attorney for SAME's former president, Cecile Villard, who was one of the Equality Nine people who were arrested protesting for marriage equality in the San Diego County building. We have a number of, we have at least three people from that, other people from the Equality Nine here tonight, including Zakia, who will be our final speaker. Our next speaker, third up, will be Fernando Lopez, who is the Public Information Director, I think I have that right, for San Diego LGBT Pride. Our last speaker will be Leo Lawrence, who, if you date the start of the queer civil rights movement in the U.S. from the Stonewall Inn riot in New York in June 1969, he was present before the creation. He co-led in San Francisco in March 1969 the first demonstration in United States history targeting a private employer for anti-gay discrimination. And he also has a JD degree, Juris Doctor, so he can talk about both how this fits into the history of queer activism and some of the legal implications. I'd like to call on Eric.
Thank you very much. Thank you for inviting me tonight. It's truly an honor to be here, and I owe it to the fact that I've got clients that have authorized me to file briefs in marriage equality litigation going back to 2004, 2005. I teach Sunday school at the First Unitarian Universalist Church of San Diego, and that church back in 2004 authorized me to file briefs supporting the right of same-sex couples to marry. We ended up filing briefs in the marriage equality cases in 2005 in the California Court of Appeal, in the California Supreme Court, filed in the California Supreme Court challenge to Proposition 8, and then moved on to doing briefs in the Perry versus Schwarzenegger, now Perry versus Brown litigation. dealing with Proposition 8. Most recent brief filed in the United States Supreme Court on behalf of California Council of Churches, California Faith for Equality, Unitarian Universalist Legislative Ministry, California, Pacific Association of Reform Rabbis, and the regional conferences of the United Church of Christ, as well as the California network of the metropolitan community churches. So the only reason I can be here to speak to you is because there are religious people and communities of faith that strongly support the right of same-sex couples to marry. Been asked to talk about what the Supreme Court might or might not do in both the DOMA appeal and the Proposition 8 litigation. Obviously, the best case scenario would be for the Supreme Court to hold that same-sex couples have a fundamental constitutional right to marry, and that both DOMA and Proposition 8 are unconstitutional for that reason. Worst case scenario would be that the Supreme Court says no way do same-sex couples have a right to marry, and neither Proposition 8 nor DOMA deprives them of a fundamental liberty interest, fundamental right, or of equal protection of the law. I don't think there are a lot of people who think that either of those best case or worst case scenarios are the most likely outcome in this litigation. There are a number of other possibilities, most of them which I think are good, if not the best case scenario. First issue that the Supreme Court has to address in a case is whether it's got jurisdiction. And there's been briefing of the question of Article 3 standing in both the DOMA case and the Proposition 8 litigation, with the U.S. Supreme Court actually appointing a Harvard law professor to brief the standing issue and to argue that there is no standing and no case or controversy over which the Supreme Court has jurisdiction with respect to DOMA. When you're talking about Article 3 case or controversy and standing, remember Article 1 of the Constitution creates the legislative branch, which makes the laws, the Congress. Article 2 creates the executive branch, the presidency, and everybody under the president who enforces the law. Article 3 creates the judicial power of the United States and gives courts the power to decide cases or controversies arising under the laws of the United States. Well, one of the things that conservatives who advocate judicial restraint push for is a very narrow idea of what qualifies as a case or controversy. They insist that you need to have a genuine dispute where the person who is filing suit has suffered a concrete, particularized injury or is going to suffer an injury quite imminently. That allows them to throw out cases that are filed by the ACLU challenging actions of the government, throw out cases filed by environmental organizations and the like. Well, one of the questions here is whether the proponents of Proposition 8 have standing to represent the interests of the state of California before the United States Supreme Court. If the answer to that question is no, they've got a generalized issue because they are not injured by the fact that same-sex couples can get married in this state, then that would terminate the case before the U.S. Supreme Court. The Supreme Court would not issue an opinion on the merits of the constitutional questions presented. It would probably vacate the judgment of the Ninth Circuit Court of Appeals, but probably leave in place the judgment of the District Court, Judge Von Walker's ruling that struck down Proposition 8. So that's one possibility, that you could get a decision from the Supreme Court that dodges deciding the issues on a procedural issue, saying there's no case or controversy because the proponents of Proposition 8 do not have standing. The proponents of Proposition 8 would be asking the court to also vacate Judge Von Walker's ruling and to at most give the plaintiffs a default judgment that would allow the two couples who filed the case the right to marry, which I don't think is the most likely outcome. I think it's far more likely that you'd end up with Judge Von Walker's decision in place and Proposition 8 ruled unconstitutional in the state of California, which would be the end of Proposition 8 and wouldn't affect other states. In the DOMA litigation, you've got the executive branch of the United States, the Obama administration, conceding that DOMA is unconstitutional. Ordinarily, if the defendant concedes the decision below by the District Court and the Court of Appeals that the statute was unconstitutional, there's no case or controversy. The decision below would stand. John Boehner created something called the Bipartisan, which I think is a misnomer, Bipartisan Legal Advisory Group, or BLAG, which I'll call Boehner's BLAG for short form, which contends that it's got standing to represent the interests of the legislative branch created by Article 2 of the Constitution before the Supreme Court defending the Defense of Marriage Act. I don't see how, if they don't have the Senate of the United States endorsing Boehner's BLAG, he can purport to speak for the legislative branch. And if he's not speaking for the legislative branch, I'm quite skeptical that Boehner's BLAG has any standing to be before the Supreme Court in DOMA. The Obama administration contends that Boehner's BLAG has no standing, but that it nonetheless has standing to get a ruling from the Supreme Court that DOMA is unconstitutional, I think because Obama would like to have the Supreme Court strike DOMA down rather than put the Obama administration in the somewhat more awkward position of refusing to comply with a law passed by Congress on the basis of a couple of district court decisions or several district court decisions. If there's no standing, no Article 3 case or controversy in the DOMA litigation, I would expect that would mean that the lower court rulings that DOMA is unconstitutional would stand and that the Obama administration would cease to enforce DOMA anywhere as a matter of federal law. That's the first issue, whether the procedural standing. And I gotta say that there are 5 conservative votes that construe standing very narrowly. At the end of February, there was a case called Clapper versus Amnesty International that dealt with the FISA wiretaps, warrantless wiretaps. And the lower court, the Second Circuit Court of Appeals, concluded that the plaintiffs in that case, which included lawyers who have represented detainees at Guantanamo Bay, included human rights organizations and advocates that were trying to track what had happened to folks that had been sent by the CIA abroad to be tortured, basically, and others. The Second Circuit said, it sure looks like you are likely to have your communications, your emails and your phone calls intercepted by this program. You've got standing to challenge it. And the Supreme Court ruled 5-4 with the 5 conservative justices, an opinion written by Justice Alito, joined by Chief Justice Roberts, Anthony Kennedy, Scalia, and Clarence Thomas, said, no, it's not a certainty that these people are going to have their phone calls and emails intercepted. They can only speculate that they might be. That's not a real Article 3 injury that's sufficient. And they said, well, you know, how can we know for a certainty that they're being intercepted? They said, it's a secret program. They're not telling us they're intercepting our emails and phone calls. To which Alito basically said, tough. If you don't know that you're actually suffering an injury from the program, you don't have Article 3 standing. Those are five justices who might take this as an opportunity to do what is part of the conservative agenda and standing, with the result that Proposition 8 would probably go down and DOMA would probably go down. If they get past standing and get to the merits, you've got a number of questions. The first question is going to be the standard of review. Is it rational basis review, which usually results in statutes being upheld on the ground that the judiciary shouldn't interfere if you've got a law that has a legitimate government interest and there's any conceivable justification for it, they tend to uphold those laws. Or should same-sex couples be a suspect classification, gays and lesbians, as a group that have been historically discriminated against, like racial minorities and religious minorities have been historically discriminated against? Should it be subject to a heightened scrutiny? Strict scrutiny requires a compelling government interest to be advanced. It requires legislation to be narrowly tailored to that government interest, and for it to be the least restrictive means of achieving that government interest. You apply strict scrutiny to either DOMA or Proposition 8, it ought to be held unconstitutional. Intermediate scrutiny, which applies to legislation that targets women or that targets people on the basis of legitimacy, whether their parents were married, is hit with intermediate scrutiny, which requires it requires the legislation be substantially related to an important government interest. Apply intermediate scrutiny, the statutes probably go down again. The Obama administration's position, this change of position with respect to Defense of Marriage Act, was based on the level of scrutiny. They initially thought rational basis scrutiny, which is what most courts will apply to discrimination against gays and lesbians. The statute will survive because there's a legitimate government interest in marriage, and you can come up with arguably rational arguments for supporting it. When they decided that gays and lesbians and laws targeting gays and lesbians should be subject to heightened scrutiny, the Obama administration changed its position on that. And it's also taken the position with respect to Proposition 8 that in states, at least, where gays and lesbians have, under domestic partnership laws, the full rights that would be accorded to married couples, that it's a violation of equal protection to deprive them of the right to marry. You could see a decision from the Supreme Court that narrows its focus on Proposition 8 to what the Ninth Circuit did and simply says that in a state like California, where same-sex couples have the right to marry, and the state of California is trying to confer on domestic partnerships all rights available to married, mixed-sex couples, withdrawing it under that one limited circumstance is unconstitutional under Romer versus Evans. You could get a broader decision that would apply to 6 or 7 states, which the Obama administration is pushing for. I think that's much more likely than a decision that says outright same-sex couples have a liberty interest in marriage like anybody else in the country, or an equal protection interest. One of the things the Supreme Court tends to do is to move incrementally and to most often lead from behind. With respect to mixed race marriages, California's Supreme Court struck down a law against mixed race marriage, interracial marriage, in 1948. It took the United States Supreme Court almost 2 decades to get around to doing the same thing in 1967. That's after passage of the Civil Rights Act of 1964. That's after passage of the Voting Rights Act of 1965. The Supreme Court doesn't like to get out too far ahead of public opinion. If this case had gone up in 2008 when it was filed, I would have thought that our odds of winning were extremely remote. But with the repeal of Don't Ask, Don't Tell, with same-sex marriage in New York, in Maryland, and Washington, D.C., with so many legal developments and the shift in public opinion that we've seen, I think there's a darn good chance we're going to see both DOMA and Proposition 8 invalidated. And if we don't see them invalidated, we will win at the ballot box because we've got a majority of public opinion on our side. And I think that's what you need me to say.
Okay, thank you, Eric.
Good evening. My name's Todd Moore, and it's a pleasure to be here. I have to say that my colleague has done a very good job at giving you the framework for which the Supreme Court's going to look at this, and there's not much that I can say about the mechanics of it. But in the request for me to be here, it was asked, what do I think is going to happen? And I do concur with my colleague that there has been a sea change. And I think what's happening, if you look just in the press, just last week, Senator Rob Portman comes out, changes his mind. Hillary Clinton today has changed her position on same-sex marriage. But there's other striking things that are happening as well. I was looking at the internet and I saw a letter from a father to his son that has gone viral. You may have seen it. But he had been in the family room of their home and heard his son on the telephone talking to his significant other, explaining the plan that he was going to put in place to come out to his parents so they would understand he was gay. And in response to that, the father the next morning had left a letter for the son that says, the only thing you need to plan to do today is bring home milk and bread or something like that. We knew you were gay since you were 6 years old. We came out then and we've loved you since you were born. And I think that's the general feeling I get, that the public opinion has changed. How does that affect what the Supreme Court's going to do? I don't know. It's like reading tea leaves. But as Eric has said, I mean, there are a lot of conservatives on the Supreme Court, and they tend to lead from behind. But understanding the issues that are out, I think the reason these cases were taken because it's time to make a decision because there is so much dissension between the states and huge issues at stake. One of the things that I think is going to happen for certain, and I could be wrong, but I do think that Prop 8 isn't going to stand. I think the Ninth Circuit opinion based on Romer is spot on, and that's a U.S. Supreme Court opinion that's been followed by the appellate courts all over this country for some time now. So I do believe that Prop 8, because the California Supreme Court originally said Californians have the right to same-sex marriage, you can now not single out people based on sexual orientation and take that right away. Whether you amend it or by legislative authority, you just can't do it. And so I think in California, Prop 8 is going to fall. With respect to DOMA, I think there is some really interesting questions that puzzle me. The issue of standing that was handled very good by Eric is really intriguing to me because it appears to me that the Supreme Court may be looking for an out on the issue of DOMA, not wanting to lead from the front, but finding a way to where it can escape a decision on it. And in effect, without doing so, affirming the lower court's opinion. So at the end of the day, we don't have an opinion by the Supreme Court that says, hey, gay marriage is a civil right and something really profound. They balk at it, but at the same time, there's laws in place to allow same-sex couples to get married. I think that's where it's going to go. Whether I'm right or wrong, it's like reading tea leaves, I don't know, but from my perspective, that's what I think is going to happen. So based on his understanding, what he's explained to you, I think we've got a pretty good forum to ask some questions when that time comes around. And I'll let the next one speak.
Okay. Next up is Fernando.
Oh. You want me to again?
Okay, might as well. Just.
Then again, my name is Todd Moore.
My name is Fernando Lopez. I am the Administrative and Public Affairs Director for San Diego Pride, former National Board Member of Marriage Equality USA. I used to work for Equality California as well as the National Gay and Lesbian Task Force. I will say that while I am up here, marriage is unchanged for 2,000 years, or however old the world is. No, that's not true. I think, I will say that I started my marriage equality activism very selfishly in 2001 when I got married myself long before it was legal. Well, not that long before it was legal. And when I married my husband, I realized that there were a series of rights, responsibilities, protections, things that all of a sudden I did not have, and decided to start advocating for those, and that's how I got involved eventually with Marriage Equality USA and these other organizations. And so at least anecdotally, I can say in the last 12 years that I've been doing this, even within our own community, the conversation is changing, and the way that we are addressing the issue of marriage equality, or even that it's something that we want to pursue. I can remember even as recent as 2008 when we were working on the Decline to Sign campaign, people within our own community were wondering what the heck we were doing outside of grocery stores with clipboards talking about an issue of marriage equality, something that we did not yet have while we were waiting for the issue to work its way through the California court system. And so even in 2008, marriage seemed unattainable to a lot of people within our own community, and I think that's really important to recognize that even in 2000, when Proposition 22 passed with 60% of the vote, now we're looking at only about 40% of California population supporting or opposing marriage equality for same-sex couples, and now we're hovering somewhere around 56% support. So Eric's right. I think whatever happens, if we were for some reason to not win in the court system now, we would see a ballot initiative in support of same-sex marriage would pass now, where clearly we lost just 5 years ago. And I might, like many behind the table, I won't bet on the court, though I would guess that we will see DOMA and Proposition 8 both go away, whether it's from a procedural standpoint, but definitely on the merits. And And Eric's right, the Supreme Court does not like to be out in front on these issues. They like to leave one behind. I thought that was really great. But what I will point out is that in 1967, this Loving versus Virginia.
Loving versus Virginia, 67.
Loving versus Virginia in 67, support for interracial marriage was only at about 20%. Public support for interracial marriage was only at about 20%. And as we're seeing, these Rob Portman, Republicans, Democrats, more and more of our leaders, regardless of political affiliation, faith leaders are coming out in support of marriage equality, and this is starting to draw the conversation forward and shift public opinion. And right now, the poll that just came out, the most recent poll, shows about 58% of the American population supports the freedom to marry for gay and lesbian people. So public opinion now for the issue of marriage equality is vastly light years beyond where public opinion was with regards to interracial marriage. So I think that gives me hope. And it's not like, it's not as though that happened in a vacuum. Since 2004, in a multitude of states, when we saw marriage discrimination initiatives passed in different states, in 2008 when we saw it here, there have been a slew of activism that has taken place in public education and organizations and coalitions that have been building very strategically in shifting and crafting the message, and more people coming out, whether it's leaders or people to their own families. I think that's what's helping to shift the conversation, and it's not just one small thing. It's a multitude of things that are happening, and we're definitely in a much better place now than we were even 5 years ago in our progressive state of California that we passed Proposition 8. Fernando Lopez, Administrative and Public Affairs Director for San Diego.
After I picked up my law degree, I did 4 years of postdoctoral study in appellate law at the California Court of Appeal. So, in fact, I have 3 of the opinions, published opinions, and I have 8 published opinions from the Court of Appeal. So I worked on the inside. I was one of those who actually wrote opinions. And one thing I recalled is that the court will typically, now I was in the state court. These cases are in federal court, different courts. But at least in our Court of Appeal, if there was a way to decide a case without having to go into the merits of the case, in other words, do it on a procedural thing, that's generally the way the court would go. And having followed both DOMA and Proposition 8, I really believe the court is going to say that there was no standing, that there hadn't been any damages suffered. So I would go out on a limb and say, I think both DOMA and Proposition 8 the courts won't even get to the merits of the issues, because they're going to say, sorry, you haven't been damaged and you have no standing before the court. Now, going back to my days in 1969, when, along with Gail Whittington, we founded the Committee for Homosexual Freedom, which was the first militant gay group in history. Back then, we were just trying to get employment rights, employment protection, and now that's quite common. Just the idea that gay rights could be before the United States Supreme Court in '69, that would be absurd. Whoever would say such a thing would be off their rocker. So it's really, really thrilling to me as a gay man that this is happening. And if things go badly, well, we could go towards the legislative route, but I don't think with the current Congress that would go anywhere. So probably the ballot would be the place to go. But there are things that each of you, now I was asked one question, is there anything that we can do to influence these decisions? And absolutely not. The cases have been briefed. They're now being considered by the sequestered court, and there's nothing that can be done to change that. So you might be thinking, all right, what will we do, especially if gay rights are upheld? I'm sure that the center will be organizing a march through Hillcrest. And if that happens, then this organization has a chance to leaflet those 1,000 or so people to get your message out. But there's something else that each of you can be doing. And that's something you can even do now, before the decision. And that is write letters to the editor. They are read. And not just the media like the Union Tribune, but community papers, such as, like Mark published, Zingers. But all throughout the city, there are community papers, and you can write, and I know, can almost guarantee that if you write a short letter to one of your community papers, it's going to get, it'll get published. But that gives each of you a chance to do something. And I would hope that you wouldn't just expect the leadership here to do things. I want to compliment Council for quite a briefing you just
You're
gave us.
one of my colleagues on the steering committee of the same alliance, and one of the members of the Equality 9, along with Sean Bohack, who is running one of the cameras tonight, and Felicity Bradley. So we have 3 of the 9 here tonight, and Zakiya will speak on behalf of the same alliance.
Hello, Zakiya Kabir, same alliance. I don't have anything to add on the legal aspects. Clearly, it's not my area of expertise, but if you need a website built about it, I can help out. I want to focus on activism. That's what SAME mostly does, is we try to mobilize and get people out in order to change public opinion and change the status quo where we feel it's necessary. And I think that, SAME started right after Prop 8 was passed, within a month, less than a month later, SAME had formed. It really is amazing how fast things changed. Because when, in the time right before Prop 8 passed, there was very little ground activity except for the dedicated people who had been working on marriage equality, like consistently, whose like job it was to work on marriage, like they were the ones who were doing it. And then it became an issue for everyone. You know, it became something that anyone on the left became a part of. I think that this decision, I think the inevitability that people are feeling, the feeling that generally the courts will rule in our favor, that same sort of inevitability happened around Prop 8. I remember people feeling like there's no way that Californians will say that Prop 8 isn't going to happen. And I don't want us to make that same mistake leading into the next couple months with the Supreme Court. I really feel that, there's only so much that we can do when it is a Supreme Court decision, but the fact that, the President, Hillary Clinton, Bill Clinton, who campaigned on DOMA, who said, like, look, vote for me because I've passed DOMA, because I signed DOMA, is now saying it's unconstitutional. These are the results of you know, a movement. And I think that I agree with Leo that there's plenty to be done in the next couple months. There is a rally planned for next Monday. People can continue to write letters, can make more statements, can pressure their congresspeople to also come out in favor. I feel like if Meg Whitman can make a statement in favor of marriage equality, then I feel like there's more, you know, there's clearly something I could do. You know, there's something that the people around me can do to make it happen. Just to sort of recap, you know, see where we've been, you know, on the first day of decision, which was a California decision, you know, thousands of people marched from Balboa Park to the Hall of Justice, and because Prop 8 was upheld. And on the second day of decision, you know, thousands of people marched in Hillcrest in celebration of Judge Walker's decision. And I think that this third day of decision, the day of decision where, I mean, I don't want to in any way say that the struggle would be over, like, if we won. Because there are so many other issues that are important. There's ENDA, there's trans rights, there's a myriad of, and even if both of these cases go down, there's still, what is it? So it'd be 41 other states that still would need marriage equality. Like, so clearly the job would not be over. So, and part of what happens at protests is building the organization and the relationships and the infrastructure in order to continue to have these fights, win or lose. I'm mostly here to implore you to, like, remember the spirit of, like, the last 4 years. You know, remember the National Equality March and meet in the middle and these Day of Decision protests and continue the fight.
Covered by the circuits that have ruled against DOMA already. And if there is a ruling against DOMA, will the people who have been denied benefits on the basis of DOMA be able to claim them retroactively?
Currently, right now, the Windsor matter that's before the Supreme Court on DOMA only addresses what was before the New York courts and the appellate court for that district. And so they are, I think it is Section 3 of DOMA, and that would just deal with benefits, federal benefits. But even if that came down to where that stood at a federal level, there's still the issue of DOMA that says states can fail to recognize another state's marriage license of a couple. So if DOMA goes down on a limited sense, meaning that they rule on standing, there's portions of DOMA that would still be in effect. And so, does that answer your question?
I think his question too would be, what's the status of DOMA in the 10th Circuit in Colorado for federal government issues in Colorado, or in the 5th Circuit in Louisiana? And I think the answer to that is that if the Supreme Court holds that there's no standing, it might not even be at the circuit court level that you have rulings. You might just have the rulings at the district court level, in the District of Massachusetts, in the 1st Circuit, and in the Southern District of New York, in the 2nd Circuit, and then, was it the Central District of California that Galinsky came up out of, which is currently pending before the 9th Circuit. But the rationale of the standing ruling in DOMA, if it was to say there's no standing, would be to say, look, here's a statute that's been ruled unconstitutional by the district court. The federal government agrees it's unconstitutional. It's for the federal government executive branch to decide whether to litigate that point. If they're conceding the point, there's no case or controversy for us to decide. I would think that the Obama administration would take that as an indication that its position that DOMA is unconstitutional is the end of it. The Obama administration wouldn't have the advantage of the Supreme Court adjudicating DOMA to be unconstitutional, but I can't imagine that it would continue to adhere to DOMA in the other circuits or the other district courts where there haven't been rulings. I think that means DOMA would be dead, and the conservatives on the Supreme Court would have the satisfaction of putting the Obama administration in a more awkward position than it would be if the Supreme Court had struck DOMA down. I'm reminded of the ruling on Obamacare. And who imagined it wasn't going to be a Commerce Clause, held under the Commerce Clause, that Chief Justice Roberts was going to say that it's under the taxing power, which the Obama administration had been saying, no, it's not a tax, putting the Obama administration in an embarrassing position at the same time that the Supreme Court upheld the statute. I think you might end up with a situation here where if the Supreme Court holds there's no case or controversy with respect to DOMA, it means DOMA is going to be dead everywhere, but it's going to be not as clean an issue as the Obama administration would have liked. I would think effective with the Supreme Court's opinion. Perhaps it would take until...
For example, not back in the day of normal accrued benefit.
It would probably go back to, I would think it would have a retroactive effect.
It would do anything that if you were denied benefits while this was pending or when it became in effect, if it was overturned, then you have the right to those benefits.
Now, you wouldn't be able to go back and reopen estate proceedings that have been closed, like 5 years ago or something like that. The Supreme Court held in a case called James Beam Distilling that a ruling of the Supreme Court on a point of law applies to all cases, not just all cases that are begun in the courts after that ruling, but all cases that are currently pending in the courts in which there's still an opportunity for there to be review by the Supreme Court.
Is that even true with IRS issues?
I would think so.
I'm not sure.
Follow-up
Yeah,
question.
but if proceedings in a case have been closed, final judgment entered, there's no pending appeal, and no petition for certiorari, there'd be plenty of instances where DOMA has done an injustice that's not going to be reopened and fixed.
It's an interesting issue. My gut feeling would be if there's a benefit that you could apply for, such as Social Security, if you don't apply from the date it's owed to you, there's procedures that you go through to get back benefits. Whether that would apply or not, I'm not qualified to answer that question.
And you know what? If there's issues where there should have been a period where you have 30 days to do something, or 6 months, or 2 years to do something, there might be a decent argument that the time limitation was told, that it was suspended until the Supreme Court issued the ruling. I can't give a final. I can't give anything more than some issue spotting here at this point.
After Obama leaves office, a new president is elected, whose administration takes the position that DOMA is constitutional and they will enforce it. If the Supreme Court has thrown out the DOMA case on standing, will a future, I'm not mentioning any names, would a future president, have the authority to enforce DOMA, and, would the process have to go all over again with another court case being brought and hopefully reaching the Supreme Court, and then would there be an issue on the merit if the federal government is actively enforcing and defending DOMA?
My understanding is that the Justice Department determines what it enforces, and that would be up to the administration. And it gets back to my original thought that even if the Justice Department doesn't enforce DOMA, it doesn't mean it's dead, it's still on the books. And if the states want to rely on it to recognize another state's lawful marriage, as far as, understand those people have the same rights in that state, the same thing would apply with the administration. If a following administration wants to enforce DOMA, I don't see anything that could stop them from doing that, because it's a law on the books.
Other than sanity.
Well, but still.
Because
yeah,
if you're talking about another administration coming in after Obama to turn around public opinion and spit in the face of public opinion at that point would be crazy. It would take a real nut job to want to do something like that. So I think as a matter of legal hypothesis, yes,
it's still in the books, and they could, whether they did
they'd be nuts.
Yeah.
If the Supreme Court is nothing, it is great on detail. I think those questions would be specifically addressed by the court if they rule on a standing issue.
There are people out there that are right-wing cuckoo birds, and I mean, if you look at CPAC, what went on, and I have to admit this right now, I'm a registered Republican, I believe in small government, but I don't like what the Republican Party is doing. And if you looked at everybody that spoke at CPAC, from Sarah Palin to Mitch McConnell to all these people and Donald Trump, I think maybe they're a fringe, but if for some reason they got the will to get enough votes in the Senate and the House and do some things and then another president, maybe. I think it's unlikely because these people with that movement, I do think they're insane, and I don't think they'll ever get into that position. But the point, because I mean, I look at public opinion, and there's been a sea change. And I don't think once you go that far, it's going to come back. But theoretically, if it happened, they could potentially try to enforce DOMA. I don't think that's going to happen.
Well, in terms of a decision of the court provoking backlash, that's one of the reasons the court tends to move incrementally. And one of the reasons that I don't expect the court to hold, as it ought to as a matter of right, that same-sex couples have the same fundamental liberty interests as heterosexuals, and that there's a clear violation of equal protection of law, and that same-sex couples ought to be able to get married in every state of the union. I don't expect that kind of a ruling, in part because of concerns about backlash. I think it's far more likely we see something more incremental, whether it's a procedural decision not to decide whether there's what the constitutional rights are in this situation, and let the lower court ruling stand, or whether it's a narrow decision that upholds the Ninth Circuit's decision on the narrow grounds that it did only with respect to California and Proposition 8, or maybe a few other states. Because if same-sex couples can marry in New York and California and a number of other states, when the Supreme Court gets around to deciding the issue again on the question of do same-sex couples have the same rights as everybody else, folks are going to say, what in the world took them so long? Of course they do. And the Supreme Court's ruling is one that's far less likely to get a backlash of motivation. Right now, there are 2 cases pending in the Ninth Circuit dealing with the right of same-sex couples to marry, one coming up out of Hawaii, one coming up out of Nevada. The briefing in those cases has been stayed, I think, into early May, and it's likely to be stayed again until we see a decision in the Proposition 8 case. And the next round of litigation will be, I think, in the Ninth Circuit on Hawaii and Nevada, which would fall under the analysis of the Obama administration's brief. And we could see, incremental movement there. And that might be, for the long run, long-run stability of the system could arguably be the best thing. Now, I'd like to see a decision that says same-sex couples have the rights that everybody else does, but if it takes a little bit longer to get there, sometimes the decision in the Ninth Circuit that Judge Reinhart wrote was one that narrowly focused on Proposition 8. He wanted to avoid holding that same-sex couples have a constitutional right to marry. He wanted to avoid having a decision that would have broad application, in part, I think, because that would make the decision less likely to be taken up by the Supreme Court and reversed. That it's a lot easier to write an opinion with very narrow consequences than it is to write an opinion that has broader consequences and strikes down laws in 40 states. So Reinhart wrote an opinion that focused narrowly on Proposition 8. They said we don't need to address the level of scrutiny. Proposition 8 fails on rational basis because the state of California has tried to give same-sex couples all of the rights of married couples in every way that they can. And is a state where same-sex couples had the right to marry, and it just makes no sense to take that right away. It fails under Romer versus Evans. That was an opinion that was written by Justice Kennedy dealing with a Colorado state initiative which deprived gays and lesbians of any civil rights protections of civil rights laws in the state of Colorado. And Reinhart was looking, I think, to get Justice Kennedy's vote to affirm with respect to California and Proposition 8, and then if same-sex couples can marry in California and Proposition 8 has been struck down, it becomes far more politically palatable in a number of senses to thereafter recognize broader rights for same-sex couples in other states. But we could very easily see a ruling with respect to Proposition 8 that is just California, or a little bit wider. The Obama administration's brief doesn't focus on California withdrawing an existing right to marry. It focuses on denying same-sex couples the right to enter a civil marriage in a state where everything else has been given to them under the name domestic partnership or civil partnership or something like that. And that would affect 6 or 7 or 8 states. And you would be on the way to getting the recognition for all 50 states, but not doing it in one blow. I think what the Obama administration is saying, if you've got domestic partnership in the states trying to confer all of the benefits of marriage with domestic partnership, there's no rational basis and certainly no compelling reason to say they can't enter a civil marriage too. They're entering the relationship that the state is going to honor and respect. Why are you going to deprive them of the dignity of marriage?
So separate is not equal.
Yeah, separate is not equal. And then you move incrementally. The fact is that we're moving a lot faster on the right of gays and lesbians and same-sex couples than we have in some of the other areas we've seen. I mean, Susan B. Anthony worked all of her adult life for the right of women to vote, and she never got to vote herself. I think we're seeing far more rapid progress. Are women's equality issues done? No, they're not. The civil rights of black Americans more than a century, but the progress that we're making is phenomenal with respect to LGBT rights.
There's levels of review for the Supreme Court. There's a rational basis, there's an intermediate or heightened scrutiny level, and then there's strict scrutiny. When you get into those things, for the court to adjust its review on how it analyzes case is a very difficult thing to do. And currently right now, and I wrote this down and said, the only cases currently right now that have a heightened scrutiny or strict scrutiny upwards are race, alienage, nationality, sex, and legitimacy. So those are the types of groups of people that the Supreme Court says if you're going to enact legislation, basically you have a rational basis unless you're part of those groups. And for the Supreme Court to move forward on a real big move, it would have to say, hey, guess what? Not only do we recognize those groups, but we now recognize the gays and lesbians as part of that group. And for them then to do that, then they could uphold what's gone on in the 10th Circuit and in New York. And I don't think the court's ready to do that. And especially because it's asked for briefing not only on whether BLAG has standing, but whether or not the court itself has jurisdiction, because the Obama administration and the lower court said, hey, guess what, we think this is illegal. I do believe it's going to skirt the issue on DOMA because it's too nationwide. However, California provides a very unique situation where Romer versus Evans is a case right on point. And I think the court will strike down Prop 8 on those
standing. That means Proposition 8 is dead, but that advances a very conservative viewpoint with respect to standing?
I think that based on how California runs its government and how people, different groups have standing, and I think that the group that's behind Prop 8 is part of the legislature, is that right?
No. No, they're the ballot proponents. They're the folks who qualified it for the ballot.
In California, the ballot proponents. Well, California ballot proponents have the right
under state law.
Under state law, and I think they might recognize that.
They might recognize that. I agree with you.
That's what I think.
They may well recognize standing of ballot proponents, although one of the decisions that comes into this is a case called Arizonans for Official English, where there was an Arizona ballot initiative to require English be the official language of all government activity in the state of Arizona. a woman who is an employee of the state of Arizona filed suit, litigated, won in the district court, and then quit her job. So she was no longer an employee of the state of Arizona who was subject to the regulation. The ballot proponents, and the state wasn't going to appeal, the ballot proponents who got the thing qualified for the ballot stepped in to take an appeal to the Ninth Circuit. Judge Reinhardt wrote an opinion holding that they had standing, and striking the ballot initiative down is unconstitutional. Goes up to the Supreme Court, and the Supreme Court, in an opinion I think written by Justice Ginsburg, says we've got grave doubts about whether ballot proponents have standing, but because in this case she quit her job, the case no longer a case of controversy, it's moot. Under doctrine of mootness, standing in time as they sometimes call it, and struck Judge Reinhardt's opinion down in the case on the basis that there was no case or controversy, which when the Proposition 8 case comes up to a panel with Judge Reinhardt, he certified the question to the California Supreme Court, do they have standing under California law? California Supreme Court says absolutely yes, they do, but that still doesn't bind the U.S. Supreme Court. The U.S. Supreme Court could hold that because the state of California says they step into the state's shoes, that's good enough for us. Or the U.S. Supreme Court could say, yeah, California Supreme Court had the Business and Professions Code provision, 17200, that said anybody could file suit in California to make businesses obey the law. Ninth Circuit said no Article 3 standing. We don't think the state can confer on somebody who does not have a concrete particularized interest and who is not part of the government. There's an indication in prior Supreme Court precedents, for example, that members of the legislature, if the Constitution and the Supreme Court of the state allow the members of the legislature to litigate in the name of the state, they could do it. U.S. Supreme Court could go either way. They could say the proponents, because the California Supreme Court says they can represent the interests of the state, that's good enough for us, just like Judge Reinhardt said. Or they could say, yeah, they're private citizens, they don't have the particularized injury that they need to show, we're not going to give them standing. I think it's up to you. Do you get to pass it on to your heirs? Do you get to pass it on to your estate or form a foundation that would take it over? And what if it's a situation where the state is defending the statute or the initiative, but you don't think they're doing a good enough job? You don't think they're doing it on the right issues? You want to intervene as a party. Those are all, questions that make it difficult to have answers for, and that make me think that I can't predict which way the Supreme Court's going to come out. I think it might go.
Well, I don't have clearly the knowledge he does on standing, but I do know something about it. And from my experience, I think that with this California Supreme Court and the Ninth Circuit, I think that the Supreme Court wants to rule on property on a state level. I really do. So that's just my issue. But I don't think they want to touch DOMA. That's more of an activist question. I mean, because yeah, and I understand that aspect. But where my mind is where's the law? And how do I keep people out of trouble? Because I'm a criminal defense attorney, and sometimes I do plaintiff's work where how does the law apply? So that's my interest in this. And I think when people's civil rights are being shortchanged, that's when I get involved. But what you do to try to change public opinion, I think you've been doing a great job. It doesn't, these issues don't affect my life as much as they affect yours. They're a concern to me, of clients of mine and things like that. But my instinct is, man, I can't wait to see what the Supreme Court does on this. And that's what I'm looking to see. How will the sea change? And realistically, we've gotten to the point where we are right now on doing just the things that you're talking about. Everybody being, advocates for a cause. And my introduction to this was through Cecile and the demonstration down at the county administration building. It moved me. There were people that were smart, educated, doing some things for standing up for their rights. And at the end of the day, when you look at it, there's nothing wrong with that. And so you keep doing it, and I hate to say it, straight people like me will change their minds. With respect to DOMA, where they don't address the level of scrutiny and the suspect class issue, I think it's going to be a slower move from a legal standpoint. And so, as far as states, it will be easier if California
is in a situation where Prop 8 struck down, then individual states will be able to look at their own constitutions and say, you know, they already have these rights and we've legislated against them, you know, we need to fix this. And those are things that can be done, but I think that the issues with DOMA are where I'd like to see the court really go. I don't think they're going.
Justice Kennedy looked at the fact that most states were not enforcing their anti-sodomy laws, that many states had repealed their anti-sodomy laws, and that European nations were no longer prosecuting people for being gay. So the trends of the law, both internationally and in the United States, and the public opinion that was behind the trends in the law in the United States and the non-enforcement of sodomy statutes in the states that still had them were something that mattered enough for him to put it in his opinion that he wrote. When he wrote the opinion that struck down the death penalty for juvenile criminals, again, he looked at the trends in the state laws that most states were repealing the statute that allowed juveniles criminals to be put to death. And I think, again, looked at European trends in the law. So Justice Kennedy is somebody who does care about where public opinion is going when you're talking about cruel and unusual punishment with respect to the juvenile death penalty and with respect to the rights of gays and lesbians in Lawrence versus Texas. That was something that
well, then there'll be no need to do anything because the lower opinions would then be in place. And so there would be in effect, by saying that the people forcing the Prop 8 litigation had no standing, that would mean that the district court decision would stay in effect and Prop 8 would be struck down and it would be done. You could get married in California.
The proponents of Proposition 8 say that if they don't have standing, that means that the most that the plaintiffs would be entitled to would be a default judgment with respect to them alone, so that those two couples would be able to get married, but the Proposition 8 would be the law for everyone else. Because I don't think it's a likely outcome.
I don't think that's going to happen.
And the issue of the ballot measures, that's one that comes back to the activist community and then the community as a whole, because you can't mobilize for a ballot initiative without a lot of money or a lot of people. Usually both. And having you know, even something popular like marriage equality is right now, according to the polls in California, is not a guarantee of a win, because when you start the counter campaign, if someone starts a campaign to deny that, those polls can start to slip away. So that's where, I mean, we're sort of winding down here, but I think fighting on all fronts is so important. I mean, I think when we leave a decision as important as this up to only the courts or only the legislature, then you really are ceding a lot of ground. Right. And I think that when you have the ability to have people in the streets, I think it can be a catalyst for many conversations that maybe people wouldn't have had the confidence to have before. I think when you can't mobilize out people in the streets, then you need to be talking to people one-on-one. I think that you need to be having meetings when you can and get as many people at the meeting in order to have that conversation. I think you need to create opportunities at any and everywhere in order to make more space. And you know, with regard to the legal question, there were those who did not want this case to go forward because they were afraid that the backlash would be so great that we would be in worse case than we started with. So I think there's a lot of just places where, you know, especially a ballot initiative, where what we do matters just as in different ways than as well.
I think the impeachment question is very easy. You need to have articles of impeachment drafted up by the House of Representatives, and then you need to get 2/3 of the Senate to vote to convict. And there's no way you're going to get articles of impeachment through the House of Representatives to impeach him for high crimes and misdemeanors. With respect to recusal, the Supreme Court has traditionally left recusal to each of the individual justices to decide for himself or herself without any clear binding standards or guidelines that are enforced by anyone. So unless Justice Antonin Scalia wishes to recuse himself, there's nobody that's going to make him do it.
Yeah, and I'll say, I'll answer your question and address these two issues. With respect to impeachment, we saw what a fiasco that was when they attempted to impeach Bill Clinton. It is just a public, it's a mockery of the judicial system is what it is, and I don't think it would get any traction. And with respect to Anton Scalia recusing himself, that's not who he is. And like Eric said, there's no guidelines for what it is. It's just how do you feel about it almost. And he likes to be in the limelight. I've seen him speak recently on something, and he was as firm in his commitment to being against everything that was about change as he always has been. And I just don't ever see him recusing himself.
Yeah, jokes about get him elected the new pope and get rid of him that way. I want to say something that I think that one of the things the framers of the Constitution got right, despite the problems it has caused us as progressives, is to give federal judges life tenure and make it virtually impossible to remove them. And the reason I say this is that in states where you see judges having to run for office, corporations have been putting enormous amounts of money into judicial campaigns to make sure that judges are elected who will not hold corporations accountable for anything. And, I'm very much of the opinion, and I've said so in public, that all states should follow the lead of the federal government and give their judges life tenure.